here. Okay. Well, thanks again for having me. I'm Scott, and I live in Ajo, Arizona. I'm not from there, but I've lived there since 2013. That's Autumn land. It's not Autumn and heated Autumn land. And I'm actually going to read something that's about 30 minutes, I reckon. And I think that'll then leave plenty of time for questions and comments that I'd love to hear from you all. Or afterwards, if you want to get going and hit the road, you can do that too. But that was going to be my hope for the evening and for the time that we have together, which I assume is about an hour or so. Um, and These talks are really helpful for me because each one is kind of a draft. I haven't really done this exact talk before, so it's a useful space for me to put it out there. And I'm always interested in feedback from all of you about any aspect of it, technical or the writing or content or anything like that. And I do have slide images here, but I'm not going to cycle through them while I'm reading. I figure afterwards we could return to them if they help to illustrate any of the key points, or if there are particular questions, we can maybe reference some of these images. But otherwise, I'm just going to leave that map up there, and I'm going to read through this in about 30 minutes, and then we'll go from there. How does that sound? Thumbs up. Okay, great. I'll get started. Um, okay. For most of the 20th century, Ajo was a company town with an open pit copper mine and smelter. In 1917, the original settlement that was mostly indigenous Ottoman and Sonoran Mexican was obliterated by digging and blasting, and so the company began building three new separate and segregated town sites, one called American Town, another Mexican Town, and a third called Indian Town. At that time, a handful of powerful copper companies operated mines across the Arizona-Mexico borderlands, like the one in Ajo, and they dominated regional, state, and local politics. The most powerful of these companies, arguably being the Phelps Dodge Company, whose overall corporate headquarters was located in New York City. PD, as everyone called the company, had a reputation for being aggressively anti-union. It orchestrated, among others, the 1917 Bisbee deportation, in which 1,200 Union members and supporters were rounded up at gunpoint and shipped out to Arizona in boxcars. And finally, the Great Arizona Mine Strike of the 1980s, which resulted in the near total decertification of unions in Arizona's mines and the closure of a number of operations across the state. That 1980 strike, PD's strike movement efforts, and the subsequent closure of the Ajo mine left that community hurt, wounded, and disoriented. And I share this context with you as a way of connecting the past to the present, but also for the purposes of making a point. If we go back to the 1980s, just before the closure of the mine, we would find about 1,200 people working in the Ajo mine and smelter. This industrial mining operation eclipsed a tiny border patrol station that had at that time just recently been built on the edge of town. And this was the first time a permanent border patrol force was stationed in Ajo, and they had the capacity for about 10 agents. Copper mining ended, of course, and those 1,200 jobs were lost forever. But by the time I moved to Ajo in 2013, the Border Patrol station had grown from 10 agents in the 1980s to a force of over 500 agents. Combine that with all the other personnel, infrastructure, and billions of dollars that were being spent on border security, and it gave one the feeling that the old economy of the Arizona-Mexico borderland, dominated by Phelps Dodge and other copper companies, had come to be replaced by a new economic model, one dominated by the corporations and government agencies heavily invested in border security. And of course, for all that it's novel and different about this new economic model, there is a strong sense, or at least I have a strong sense, that the underlying dynamics and social relations of the new era are perhaps not all that different from the days of Phelps Dodge and the company town. The 1990s was pivotal in the growth of the new border security industry nationally and especially in southern Arizona. In 1994, Border Patrol adopted Prevention Through Deterrence, the deliberate effort to push migrants into rugged and remote terrain, as its agency's official strategy. The effect has been the deaths of thousands of migrants from exposure, thirst, and other injuries in remote areas along the border. In Arizona alone, there are now over 4,000 documented deaths since the policy was implemented. In response to this humanitarian crisis, civilian NGO groups formed to provide humanitarian aid, medical care, and search, rescue, and recovery in the Arizona borderlands and elsewhere. And when I moved to Ajo in 2013, I got involved with a couple of these groups, No More Deaths and the Ajo Samaritans. An area of particular concern at that time was the remote Growler Valley, located west of Ajo within the Cabeza Preta National Wildlife Refuge. In 2017, we approached refuge managers asking for permission to drive administrative roads and leave water in areas where people were dying. They wavered in their response, so we let them know that we would go ahead and do it anyway. We did, and several volunteers, including me, were subsequently charged with misdemeanor offenses for these actions, the primary of which was the charge of, quote, abandonment of property for having left water jugs behind in the desert where people were dying of thirst. At about the same time, Border Patrol agents from the Ajo station's so-called disrupt unit had begun surveilling the barn. There's no farm animals at the barn. It's just the name of the local property owned by our town's retired physician and used by No More Deaths and other humanitarian aid groups as a base camp in that area. Two agents set up surveillance for adjacent public lands, and when they saw me outside talking with two men whose names are Jose and Cristian, they determined somehow from 200 yards away and through a spotting scope that Jose and Cristian were portrayed illegally. The agents then led a convoy of Border Patrol and sheriff vehicles onto the property and arrested all three of us. Jose and Cristian for the crime of being in the country illegally, and me for the felony crime of, quote, harboring aliens, for having given Jose and Cristian, in the words of the agents, food, water, beds, and clean clothes over the course of their 3-day stay at the barn. Now, suspected in the case of the misdemeanor charges, prosecutors chose the abandonment of property charge, likely due to the fact that No More Deaths had more or less successfully defeated charges of littering brought against them for having left water on a different federal wildlife refuge in southern Arizona in 2007. In the case of the felony harboring charges, Border Patrol stated reasons for surveilling the barn were always impressively malleable and ever-shifting. They implied that they were responding to community members' concerns about migrant-related trash in the vicinity, or maybe they were conducting some kind of search and rescue operation for missing migrants, though they never could produce a report or give a description of the missing people for whom they were supposedly searching. We charged with the surveillance and arrest part of a targeted campaign against No More Deaths for its criticism of the Border Patrol. Earlier in the day I was arrested, for instance, No More Deaths released part 2 of its Disappeared Report series that documented Border Patrol's harmful and risky enforcement practices, such as, among others, destroying humanitarian aid supplies left for migrants in the desert. Through discovery, my lawyers and I learned more. Earlier in the day I was arrested, agents had in fact been made aware of the critical report and had discussed the fact that representatives of No More Deaths were going to appear on the local 10 o'clock news to discuss its destruction of humanitarian aid supplies. Oh wow, that's awesome, tested Border Patrol agent John Rambo Marquez, wondering who they are going to blame. Later in the day, it was Agent Marquez and Agent Burns who set up surveillance at the barn. And after seeing me, Jose, and Cristian talking outside, Agent Burns sent a group text to a team of Border Patrol agents declaring that there were, quote, tonks at the barn. Now, tonk is an offensive but old Border Patrol slang term for migrants. It describes this term by one of those old, oversized flashlights that run on E-size batteries makes when hit over the top of someone's head. Upon learning this, Agent Albert calls by a seraph to expect the group, what? Nice. Agent Marquez responds, yep, we are going to be live soon. Ha. They then rush the property, aggressively and without a warrant. When I immediately informed the agents they were on private property, a humanitarian aid station, and told them that they had to leave, they all froze for a moment and glanced back and forth at one another. Then Agent Marquez said, and without much confidence, I would add, well, this is a public driveway, and I'm just going to go and knock on the front door of that house. Later in court, they claimed the entire operation a quote knock attack. Months later, in a motion to dismiss hearing, based on the fact that agents had obviously violated my constitutional Fourth Amendment rights, Agents Burns and Marquez suggested that, sure, they remembered the interaction, which I said, the barn was private property. But no, they didn't really remember, or maybe they couldn't really hear whether I had explicitly told them to leave or not. And a very chummy magistrate judge with their version of events stand as fact, and our motion was not granted. Um, so legal scholars and experts reached out to us, to me and my legal team, No More Deaths, after the word of the arrest spread and suggested that we might have a strong defense against both the misdemeanor charges and the felony harboring charges by using the Religious Freedom Restoration Act. The Department of Justice, headed by Jeff Sessions, after all, had affirmed its commitment to aggressive immigration enforcement, including the use of the harboring law broadly against anyone helping migrants in any way. But it also announced a policy of deference to and respect for individual religious liberty. The Religious Freedom Restoration Act, or RFRA, RFRA for short, was passed in 1993 with broad bipartisan support. Though I must say that my lawyers and I, along with many in No More Deaths, were initially skeptical of the law, having associated it strongly with the 2014 Hobby Lobby ruling, in which that company used a RFRA claim to deny giving its employees contraceptive care. RFRA functions, and here I'll say I'm not a lawyer and it's giving legal advice, but my interpretation as a defendant being involved with this case. But RFRA functions essentially to add a burden to a prosecutor's case where a defendant's actions in breaking a law are religiously motivated. Here, religion is not defined solely as organized religion, but is expansive enough to include various forms of spirituality and religious-like worldviews. In a RFRA claim, prosecutors really shouldn't question the validity or truth of any particular religious belief or practice, nor should we question the centrality of a particular practice to the defendant's overall belief structure. Prosecutors, however, can and do challenge whether the beliefs actually rise to the level of traditionally religious, and not, say, a belief that is rooted in a political or philosophical worldview, and they can and do question whether the defendant is sincere in their beliefs. If the court finds that the defendant's beliefs are religious and sincere, and if the defendant's actions were religiously motivated, then prosecutors must show that they still have a compelling interest in prosecuting that defendant, and importantly, the argument that, well, hey, it's the law, and the law applies equally to everyone, is generally not considered a compelling government interest in a RFRA. And prosecutors have to show that the government, in pursuit of a goal like immigration enforcement, is pursuing the least restrictive means possible in achieving that goal by prosecuting the defendant for their religiously motivated practices or actions. And if you're like me, I'll have tons of questions on how this actually plays out in court. It's fascinating and troubling and all those kinds of things. Now, the so-called harboring law, though, is the broad legal framework that can punish those U.S. citizens or otherwise who aid or support migrants in some kind of way. Critically, prosecutors have to show that a defendant in aiding or supporting migrants did so with the intent to avoid immigration enforcement or violate the law. The harboring law is a product of the expansive 1952 McCarran-Walter Immigration Act, and contained within this larger act was the specific language related to harboring, which made it a federal felony to, quote, transport, shield, conceal, harbor, or encourage alien to reside in the country. And I think it's important to mention the context of the 1950s, of course, when the act was passed. And I won't belabor this term, just speak clearly about how it was talked about at that time, because this legislation was known widely and popularly, most commonly as the, quote, Red Bill. It was passed during a period of renegotiations between the U.S. and Mexico on the Bracero program, which of course brought millions of Mexicans to the U.S. as official guest workers, while also still at a time of widespread employment of unauthorized Mexican migrants as workers in agriculture industries, and just before a period of a mass deportation drive campaign carried out by the Border Patrol and led by a charismatic former military commander. Agricultural interests, especially those in the politically powerful states of California and Texas, were of course major players in the politics of the 1950s. And the Texans especially chafed at the idea of the federal government inserting itself into their employment practices, either through Rosero or a harboring law that could potentially be used against employers. And so that state's congressional delegation ensured that the infamous Texas proviso was added to the language of an act. And it read, quote, provided, however, that for the purposes of this section, employment, including the usual and normal practice of incident to employment, shall not be deemed to constitute harboring. This Texas proviso stood for 34 years, though it was struck from the harboring law in 1986 with the passage of the Immigration Reform and Control Act. And that act, of course, did institute for the first time in this country employer sanctions. But despite this, I would argue that the spirit of the Texas proviso is alive and well, especially in agriculture, and even apparently, especially within this current presidential administration. All this to say, had it not been no more deaths, but rather a sprawling farming conglomerate of politically powerful Republican Party donors, I suspect there would have been no issue with providing food, water, clean clothes, and beds to two undocumented men who also happen to be employees. But of course, those corporate entities don't have the best track record of providing basic human services to their employees, right? But all the politics and obvious double standards aside, the issue in the harboring law is less about the particular kinds of actions taken, but rather one's intent in taking those actions. I'll just go to a quick note about the outcome here, and then we'll come back to talk about some of the dynamics of the trial. But there were some ways that we did and we did not actually use that RFRA, the Religious Freedom Restoration Act, as a defense in these trials. In the misdemeanor case, that abandonment of property case, which was a 3-day bench trial in front of a judge, a new jury, a bench trial, and in that trial, we did use a RFRA defense. We were ultimately successful. In the felony harboring case, which was a jury trial, we set up RFRA to use as a potential defense, but ultimately we did not use it. Instead, we argued, and the jury eventually came to unanimous agreement on this, that the government had not proved that I had violated any law in giving Jose and Christian food, water, beds, and clean clothes, among other things, over the course of 3 days. And it's the events of the felony trials that I'll turn towards now. I say felony trials because in the case of the harboring charges, there were actually 2 trials. In June 2018, after their initial 9-day trial, both sides closed their arguments, and 4 of the 12 jurors thought the prosecutors had shown that I was guilty of harboring and a concomitant charge of conspiracy to harbor. 8 of the 12 jurors thought I was not guilty. And since the difference between these 2 camps of jurors had apparently been irreconcilable, the judge declared a mistrial. And afterward, prosecutors, defense attorneys, and several jurors chatted informally. And from conversation with the pro-acquittal majority group of 8, my pro bono lawyers, Ray Kirkendall and Amy Knight, learned that the 4 jurors in the pro-guilty camp had been obstinate during deliberations. They felt apparently that a not guilty vote would be a tacit endorsement of the defendant and border humanitarian aid groups such as No More Deaths and a kind of indictment of the Border Patrol. It assumed that these 4 jurors would stand on the side of law enforcement no matter what. Prosecutors, of course, needed an unanimous jury in order to secure a conviction. So a hung jury with an 8-4 split in the defendant's favor is definitely a win for the defense, though it allows prosecutors the opportunity to try again, and a few weeks later they announced that they would in fact retry the case. So in the run-up to the second trial, we worked closely with Karen Lisco, the trial consultant who gave excellent advice. Think of the trial, Karen told me, as a college seminar on the topic of geography, the border, and the events at issue. The courtroom is your classroom. You are the instructor of record. Prosecutors don't realize they are enrolled in this course. They will be assertive and convinced of their interpretation, but they are wrong. As you would with any student, offer clarification, context, and respectful correction. Never try to make them look bad, and don't be condescending. Karen also organized mock trials with focus groups of mock jurors in Tucson. And most of these mock jurors thought our arguments were compelling and convincing, but again, a minority thought that the case once again distilled down to the issue of law enforcement, border patrol, versus humanitarian aid or no more deaths. This minority group also chafed at the way my lawyer aggressively cross-examined border patrol agents. They felt that the lawyer was trying to make the agents look bad and that he was being condescending and disrespectful to them. Now, we felt quite justified in an aggressive defense that called into question the credibility of the Border Patrol agents. But this was poisoning the well, so to speak, with a minority of the jury pool. And while we could claim another win with another hung jury in this trial, there would be nothing formally stopping prosecutors from continuing to retry the case. In that second trial, then, prosecutors made a few changes around the edges, but the core of their argument remained the same. That the Border Patrol agents' interpretation of events was the one and true interpretation, and that the arguments my lawyers made were misleading, and the testimony I gave as a defendant was a lie. We still put up an aggressive defense, I think, but we made an important course correction. A friend and close observer described this change, noting that in the retrial, we seemed less like aggressive defense attorneys and instead more like educators and teachers. When prosecutors narrow the scope of events in hopes of making the case a credibility contest, we didn't reflexively and call into question the credibility of the Border Patrol agents. When prosecutors presented events out of context, we recontextualized them. When prosecutors told the jurors that I had to be lying in my testimony, we told the jurors that the Border Patrol agents were not lying in theirs. And importantly, that there need to be no individual conflict in both believing the sincerity of the agent's interpretation of events and voting not guilty. Underlying the strategy was the core feature of the harboring law, the issue of intent. Giving someone a set of clothes might be considered harboring. For instance, if prosecutors can show the intent behind this act is to, say, help a person blend into the local community for the purposes of hiding from law enforcement. It might not be considered harboring if the defense can show that the intent is to give someone protection from the weather and from the elements. Pivoting on intent, therefore, my defense attorneys and the prosecutors told the jury very different interpretation about what the facts of the case meant. Namely, what it meant to give someone food, water, clean clothes, and beds, and perhaps most interesting to a geographer like me, what it meant to be standing around outside with someone and talking about the landscape. My lawyers, I think, navigated all this with precision and expertise and helped the jurors make an observation about Border Patrol and its practices, but not necessarily a judgment. Agent Burns and Marquez's interpretation of events, he explained, fit perfectly within the context of what I would call here an overarching Border Patrol worldview or milieu. Given this milieu, it was reasonable, perhaps even expected, upon seeing the three of us outside talking, surveying the landscape, that Agents Burns and Marquez would conclude that I was giving instructions on how to evade Border Patrol protection. To drive, after all, so the government's argument meant, what else could one possibly be doing standing around outside, talking about the landscape and pointing to, quote, large green features in the Ajo Border Patrol Station's area of responsibility, unquote. To drive this point home, Agent Burns took the stand and gave the jury a detailed geographic orientation to the 40 or so miles of desert north of Ajo. With maps, photos, and satellite images, he pointed out and discussed prominent peaks and passes, dirt roads, the highway checkpoint, the town of Gila Bend, and the green irrigated fields along the Gila River. He talked about his experiences as a Border Patrol agent in this area, what he had learned about the place, and how particular cases and locales within it related to the agency's overall enforcement mission. Both Agent Burns and Agent Marquez showed in their testimonies, honestly and legitimately, that they had a knowledge of the place that was extensive, intimate, and experiential. But it was the language they used in talking about that place that revealed something about a Border Patrol way of seeing. Mountains were, quote, large terrain features that aliens use to navigate in the Aho Station area of responsibility. Passing through these mountains were simply alien layout sites. Dirt roads were important only to the extent that, quote, aliens walked them in order to circumvent the checkpoint, and law enforcement drove them in pursuit. The morning after Agent Burns' testimony, I wrote my reflections on his extensive geographic orientation. I wrote it down, of course, and I sent this document to my lawyers. And I am an academic through and through, so I opened that document with an epigraph from Don Meinig's article, The Beholding Eye, 10 Virgins on the Same Scene, from his classic 1979 edited volume, The Interpretation of Ordinary Landscapes. You probably know it. Meinig says, quote, in viewing landscape, the difficulty inevitably arises as soon as we attempt to communicate about it. A simple exercise reviews the problem. Take a small but varied company to any convenient viewing place and have each describe the landscape. It will soon become apparent that even though we gather together and look in the same direction at the same instant, we cannot see the same landscape. We may certainly agree that we will see many of the same elements, houses, roads, trees, hills, but such facts take on meaning only through association. They must be fitted together according to some coherent body of ideas. Thus, we confront the problem. Any landscape is composed not only of what lies before our eyes, but what lies within our heads. There was nothing, he said, nothing disingenuous about the way that Agents Burns and Marquez looked at the landscape and then interpreted what was there to the jury. But that interpretation reflected not only what was there, but also what they projected onto it. This projection, this arbitrary way of seeing the landscape, served as the foundation upon which they interpreted the actions of others in that landscape. There was much, therefore, that Agents Burns and Marquez did not see. Perhaps much that they simply could not see about the place. When I took the stand, I explained that Jose Cristian and I were orienting to the very same elements of the landscape for the purposes of their physical safety, and that this safety orientation was necessary because several hundred people had died from becoming lost, injured, or disoriented in that very same desert. Now there is much, of course, that I've omitted in the story of the trial in hopes of presenting, a concise narrative here. And it might go without saying that these geographic insights on landscape that I was just discussing, were not in and of themselves sufficient to making our overall argument, but they were, I think, most definitely a necessary part of making that overall argument. In his closing statement, my lawyer, Greg, didn't quote that Don Meinig quote exactly, but he did paraphrase and adapt. A border patrol agent and a humanitarian aid volunteer trained as a geographer, he told the jurors, may be looking at the same landscape, but their interpretation of it differ, and therefore so do their conclusions about what is happening there. Your job as jurors is not to take the side of either the agents or the defendant, but rather to consider that multiple interpretations and conclusions can coexist. Now, if that sounds reasonable to you, that's one way you arrive at reasonable doubt. And in that second trial, after 90 minutes of deliberation, the jury came back to return the unanimous not guilty verdict. So, by way of conclusion, so I'm standing here and talking to you today as a former defendant in these cases, but the community of those directly affected by these cases, those engaged in the defense, and those broadly in solidarity is vast and wide, and I know it includes people here in this room. It includes so many people, and obviously my outstanding pro bono attorneys and many others who volunteer their time and effort. And I would say it especially includes Jose and Cristian, the two young men from Central America arrested along with me. The government detained Jose and Cristian for several weeks, and in exchange for their testimony, they were promised only a speedy deportation without criminal prosecution. In the court depositions, prosecutors aggressively moved to cut short any of Jose Cristiano's responses that began to shed light on the complex lived experiences of these two young men. Nevertheless, they talked about, and it was recorded in the court record, but they talked about how they traveled across Mexico, navigated the desert between the border and Ajo on foot, and how they planned to continue walking northward. They talked about the need that drove them, which, of course, is to provide for their families and find safety from a multitude of threats in their home countries. And they talked about the relentless violence and exploitation that seemed to follow them everywhere on their journey. That's prosecutors interrupted. But how did you know where to go? Who told you where to go? To that, Cristiano replied, we researched the best way to go on my phone. I have a compass app that tells the direction, and at night, we found our way by the stars. We took care of each other. So, thanks. Well, thanks. I'll take a sip of water. There's plenty of time. If folks need to leave or questions, comments, just I'm always going to hear. Uh, I had that same resistance myself that you're describing, and I credit a lot of that to my lawyers, the trial consultant, who worked with us also on a pro bono basis, and she basically said, "This is what you have to do. This is how this works." Is that what I didn't talk about actually is you need to be the host. You didn't choose to be here, but as the defendant, everybody is going to be looking at you, and you need to sort of take on the energy of your hosting this, like it or not. And the whole thing that she said about the college seminar, she kind of tailored that to what she knew about me, of course. And boy, yeah, my lawyer Greg in particular just relished the opportunity to take down a border patrol agent on the stand. And he also had to adapt this kind of much less aggressive defensive posture and this more sort of holistic container in a way. In a way, it's beautiful. And yes, it was a challenge. It took a bit of a mental shift. Yeah. Yeah, I'm going to switch really quick to review, which allows me to see the slides. If we need to scroll through the slides, we can do that. Just excuse me for 1 second. Yeah, okay. Almost there. Oh, I'm sorry. Oh, okay. Yeah. Thank you for your patience. I'm getting there. Okay, one more step, I think. Always risky to do this in the middle of a presentation. Okay. Okay, that's right. We had a couple of questions. I think you and then somebody else. Yeah. So, and to clarify, it's not as if we had no sense of the sort of psychological approach that you were describing in the first trial, and we adapted scratching the second trial. The harboring law has this key word of intent built into it. It's not the action, it's the intent taking that action. And we all might wonder, why is the law written that way? It's a good question. I suspect that it has much less to do with providing protections to humanitarian aid workers and still providing ample protection to employers. Because all those actions, and this administration, if they had wanted to, could have said, we are aggressively going after all those employers who are knowingly employing people who are without authorization. And instead, I think what we've heard is actually death threats and, oh yeah, maybe we'll figure out a way to, for hotels and farms and these sort of things to get the labor we need and all that. So intent is always there. So it always has a kind of psychological element to it, which is what we've understood in humanitarian aid work, right? Is that and what guides us is sort of the knowledge of the law, with the space of the law, sort of allows going out and putting out water in the desert. So people would like to say, well, the intent of that is to encourage people to cross illegally, putting out water in the future. And of course, we come back to the intent argument that it's about preventing death and suffering in the desert. So, yeah. Yes. Oh, the mock jurors in Tucson, they had two different groups of jurors. So it was a full day, and lawyers presented their arguments and ran through a few things. So it wasn't like a full 9 day trial, but yeah, yeah. This work continues, um, and I continue to be active in it, but not nearly as active as before. It's kind of life changes, and I prefer to do other things and to be here and doing a talk like this, and so that's my focus. But there's a lot of work involved in these humanitarian groups, and not just the direct aid, but yes, that still goes on. Just in December, there are few people crossing the border. I think that's true, but people are still crossing, still out in the desert, and more deaths. Humanitarian aid camp near Aravaca, which is kind of between, it's not keeping around this on the map here, was raided by Border Patrol, and they arrested 3 migrants who were receiving care. They didn't arrest volunteers. They didn't bring any charges against volunteers, but this is a regular action that Border Patrol every once in a while to go in. They went in without a warrant again, and they arrested 3 people, migrants. So it continues. Yeah. Yeah, we'll go back here, and then we'll get you up there. Yeah. Um, the Peter Andreas' book, Group Games. It's a great book. It speaks to this directly. Geographer, yeah, border games, and it speaks to that whole notion of presentation, and that we've been talking about this in some classes the past couple of days. But if you really want to understand what's happening at the border and what drives policy, is that one needs to have a real sensitivity to the political performative nature of it, which is not just this administration, it's many administrations, which looks something like you run on a campaign of, oh, the border is a mess, the last person totally screwed it up, and this is crisis, and this is bad, and I'm going to fix it, and do all these things. You come in, you do something big and splashy and showy, get a lot of media attention, and then you declare victory, whether or not any kinds of metrics of success have actually been achieved. It was true in the 1950s with that mass deportation campaign. It was true in many administrations. And so I think like you're alluding to, having an understanding of the political performative nature is always important, maybe the most important thing for understanding the border. Yeah. Yes. Yeah. Great question. When word got out, so number that's had a whole media team that sort of put the word out there, and then we were contacted by law firms, several different law firms who were interested in representing me, and then other defendants who had the misdemeanor charges, somewhat less serious charges, but there were several defendants there. And they reached out saying they were interested, and so No More Deaths basically had a spreadsheet of lawyers, and some were very prominent, powerful firms across the country. But the advice we got is like, of course, you want somebody who's competent, but you need somebody local, because even in federal court, like you need somebody who's from Tucson, has argued cases in Tucson court. You don't want a New York law firm necessarily coming in that might not be good for you. And so friends interviewed a bunch of lawyers, and the two that represented me, Greg Kirkendall and Amy Knight, were just kind of excellent, had context from working on a lot of what they did were death penalty defense cases uh, uh, that were funded by Mexico for Mexican nationals in the U.S. who faced the death penalty. And so they did a lot of that work. So they had a whole bunch of familiarity with, of course, my case is very different, but familiarity with Border Patrol, kind of law enforcement and prosecutorial system. So they were pretty seasoned in that kind of work. Yeah, yeah, absolutely. Yeah, yeah, we sure did. I mean, many of the folks that we brought in to testify. So, like data that you all have worked with here, for instance, like this map is a big point of debate in the trial. Basically, we used it to justify that humanitarian aid work is necessary, and prosecutors tried to undercut it. So we brought in several folks that were involved in compiling this data to testify about that. And then, yep, amicus briefs, especially in the context of the Religious Freedom Restoration Act, because that was something that my lawyers didn't have experience with. And so we got a bunch of support, um, and especially from the Law, Rights, and Religion Project, which is now at Indian Theological Seminary in New York. And those guys have done a lot of work. And I was just in New York, so they gave me a stack of informational things. So I'll have them here if anybody wants to learn about that group. I'll put them out here. Um, but yeah, they were the ones that wrote the just briefs in many of those cases and really helped us out. Yeah, 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 absolutely. Thanks for that. Yeah, yeah. There's so much, we could talk about in terms of despite all of the formality and kind of dehumanizing distance of the courtroom, strange ways in which there are these kind of humanizing moments. We've been talking recently, about just uh, again, my lawyer is relished the idea of taking down the board intelligence, but there were a lot of interesting dynamics there. I think those jurors, for instance, weren't just that minority of jurors weren't just reacting to the fact of, well, I'm for law enforcement, but like I really like the way that this well-educated attorney guy is talking to these working class law enforcement guys. That doesn't feel good to me, even though I mean they lied in their testimony and that kind of thing. So you're bound holding that sort of accountability framework, and also whatever wherever you can find that commonality or some kind of space. But yeah, 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 yeah. It's beautiful, and I have to admit some of that is the effect of the narrative device I'm using here. I mean, because there certainly were other sort of cut things that my lawyers still did when it was necessary. Like it is just this thing about being in a kind of legal fight, and everyone is clawing for whatever advantage. It's really not pretty. It's just not pretty. But yeah, there was something beautiful about being able to carve out a little bit of that space that you're talking about. Yeah, yeah, yeah. I mean, and it's basically what we talked about in the class is that going back to the 1990s, the whole prevention through deterrence policy was a reflection of at that time negotiations around NAFTA. So NAFTA policy that was throwing the border wide open to capital and money and goods and services, and that people knew was going to devastate Mexico, Mexico's agricultural economy and all that kind of stuff, and sent people north. And so then they also had this potential for deterrence policy of militarizing the border and pushing people out into these desert regions. And then, we're now in this period of wall building, and again, it's not a literature that I spent much time in, but impacts of climate change in Central America already changing agriculture and people being pushed north by that. And now here we are in this, whether it's a continuation of prevention through deterrence or whether it's a new phase of it or something completely different, this wall building stuff. Um, it is sort of preparing for maybe a next wave of people, if that's how they're thinking about it. And so the logic is pretty brutal. I mean, it is brutal, of these enforcement strategies. Yeah. Yep. Yeah. No, there were. That was another interesting part. This with all the exhibits. And, those border patrol agents used their own maps and in subtle ways. Just angles of camera photos. I mean, But it's a beautiful sunset picture of the barn, or one of the photos they took at night, like through the windows and whatever. So all kinds of things. But it was really this map in particular in the misdemeanor case. So this is the Growler Valley. Uh, yes, Growler Valley, kind of west Tahoe, really remote area. Um, these look like they're roads. They're just four-wheel drive, two tracks, really rough roads going out there. This is where certain arrests weren't arrested in those misdemeanor cases, but we were cited and summoned to court. But this is where we were putting water. Here's the corridor. That just in the year previous, there'd been several dozen documented recoveries of people's bodies in this area. And part of it was an effort by a lot of these search and recovery groups from Southern California, most of it being made up by folks that had themselves across the border previously or had family and friends that had done that. And just finding many, many cases of where people had died. And so that's why we're putting water in that area. It wasn't, a random thing, just a new part of the desert. That was that particular spot. And so, yeah, this map in particular, yeah, prosecutors thought of every conceptually they could challenge the validity of the data. And, well, you didn't do the recoveries yourself. Or saying, well, you don't actually know the cause of death. I see all these where the cause of death is undetermined. You have no idea. And so you don't know if this person was a migrant or something. And I just remember he's an older gentleman, geology PhD, who started doing all this mapping. And he said, well, I know they weren't hit by a car. And it's interesting. I mean, in some ways, like you're not making a legal argument in that case. You're talking to 12 jurors, 12 regular people, and so you're trying to connect with them. And you find all these different kinds of ways. Sometimes, like that folksy approach is what resonates. So, yeah, yeah, but, yeah, yeah, totally. Yeah, I mean, Border Patrol is a big institution now, and like the military or any of these institutions, it can be a social stepping stone, and it is especially for like you know second generation folks who their parents were immigrants, and many of their parents were undocumented immigrants, and they joined work. That's not uncommon across the border, and you definitely see that. And so, yep, I mean, I think we shouldn't be necessarily judgmental of whatever the mental gymnastics might be, or maybe just not thinking about it, because I think we all do those kind of things in aspects of our lives. But I think kind of like the copper mining industry. I mean, you had enormous political movements and union movements in southern Arizona. Um, this was the book about the so-called Bisbee deportation in 1917. Just conflict, but in some ways everybody was touched by that industry, and people's livelihoods were attached to it. And in some ways, this whole border security industry has a similar kind of thing, and it wouldn't be so easy to just yank that out of the border region any more than it would be to like remove, say, a military base from the community or something. It's the same kind of complicated, um, economic uh, connections and social connections. And so, my interest in using extractive history as a metaphor to talk about border security is all in all of its complex ways, not just that has an enormous impact on land and life, but that it is a kind of society shaping industry that has all these implications. So, yeah. Well, I don't know how we're doing in time. We're about up to an hour, but yeah, yeah, yeah. Good question. I was teaching at ASU, Arizona State University, and they initially distanced themselves. Uh, yeah, I didn't remember it being all that harsh or anything, but a colleague of mine recently was just like, I can't believe that they did that. And the statement was something like, well, he got arrested for doing this thing. It doesn't really have anything to do with his teaching here. It's totally separate. That was all kind of extracurricular, which it wasn't necessarily the university activity, but I had got my PhD there and taught there as a lecturer for a couple of years, brought students to the border and all this kind of stuff. I think that was just a kind of initial fear. That was early on in the first Trump administration. I think just like now, how we've seen a lot of fear, like in this first year, and then in the context of my trial, I think as the years went by, and particularly after the midterm elections, there seemed to be a whole lot more courage, so to speak. And so, I mean, individual instructors, professors at USU were very supportive and reached out to me, and they formed groups of support, wrote letters, and the university presented really supported me. A bunch of things there did during that second felony trial. So it is very interesting just to watch the institutions navigate these things, and sometimes they fall on the side of acting more courageously and sometimes less. We've seen, so. Yeah, thanks.